Members of the jury, all the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law which I'm about to give you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you and not as you think it is or as you might like for it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied to him or her. In this case, the attorneys for the state and the defendant have made opening statements. The purpose of an opening statement is narrow and limited. It is an outline of what the attorney believes the competent and admissible evidence will be. Opening statements are not evidence, and you must not consider them as evidence. The evidence came in the form of the testimony of the witnesses, admissions of the parties, stipulations of counsel, or any physical exhibits that were offered by the parties. You must disregard any statement that an attorney made in their opening statement that was not supported by the evidence that was admitted in this trial, and you must not consider it in any way in your deliberations. The attorneys have also made final statements or arguments. The final arguments of the attorneys are not evidence, but they are given to assist you in evaluating the evidence. Your duty is to decide the facts from the evidence. You and you alone determine what the facts are in this case. If an attorney attempted to restate a portion of the evidence and your recollection of the evidence differs from that of the attorney, you are to be guided by your recollection. In my discretion, I have allowed you to take notes during the course of this trial. When you begin your deliberations, you may use your notes to help refresh your memory as to what was said in court. I caution you, however, not to give your notes or the notes of any of the other jurors undue significance. Any notes taken by you are not to be considered evidence in this case. Your notes are not an official transcript of the trial. For that reason, you must remember that in your jury deliberations, notes are not entitled to any greater weight than the individual recollections of the other jurors. The defendant has entered a plea of not guilty. The fact that the defendant has been indicted is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or lack or insufficiency of the evidence, as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the credibility, that is, the believability of each witness. You must decide for yourselves whether to believe the testimony of any witness. You may believe all or any part or none of what a witness has said on the stand. In determining whether to believe any witness, you should apply the same tests of truthfulness which you apply in your everyday affairs. These tests may include, among other things, the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which he or she testified, the manner and appearance of the witness, any interest, bias, or prejudice that the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. Excuse me. You are the sole judges of the weight to be given to any evidence. And by this I mean, if you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all the other believable evidence in the case. The defendant in this case has not testified. The law gives the defendant this privilege. This same law also assures the defendant that the decision not to testify creates no presumption against the defendant. Therefore, the silence of the defendant is not to influence your decision in any way. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in this case, and after weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Proof of motive for the crime is permissible and often valuable, but never essential for a conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of a motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus provided, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. Evidence has been received tending to show that Nancy Cooper made statements to various witnesses regarding the status of her relationship with the defendant, Bradley Cooper. This evidence was received solely for the purpose of showing Nancy Cooper's then existing mental, emotional, or physical condition. If you believe this evidence, you may consider it, but only for the limited purpose for which it was received. You may find that a witness is interested in the outcome of this trial. In deciding whether or not to believe such a witness, you may take the witness's interest into account. If after doing so you believe the testimony in whole or in part, you should treat what you believe the same as any other believable evidence in the case. Photographs, diagrams, and maps were introduced into evidence in this case for the purpose of illustrating and explaining the testimony of a witness or witnesses. These photographs, diagrams, and maps may not be considered for you by any other purpose. Photographs and videos and diagrams were also introduced into evidence as substantive evidence. These photographs and videos may be considered by you as evidence of facts they illustrate or show. I instruct you that the state has the burden of proving the identity of the defendant as the perpetrator of the crime charged beyond a reasonable doubt. This means that you, the jury, must be satisfied beyond a reasonable doubt that the defendant was the perpetrator of the crime charged before you may return a verdict of guilty. In this case, you have heard evidence from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, and whether the opinion is reasonable, and whether it is consistent with the other believable evidence in the case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you're not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. When evidence has been received from a witness in the form of an opinion, you may only consider the opinion of a witness which is rationally based upon the perception of the witness and helpful to a clear understanding of the witness's testimony or to the determination of a fact in issue. When evidence has been received tending to show that at an earlier time a witness made a statement which may be consistent with or conflict with his or her testimony at this trial, you must not consider such earlier statement as evidence of the truth of what was said at that earlier time, because it was not made under oath at this trial. If you believe that such an earlier statement was made, and that it is consistent with or does conflict with the testimony of the witness at this trial, then you may consider this, together with all the other facts and circumstances bearing upon the witness's truthfulness, in deciding whether you will believe or disbelieve the witness's testimony the witness's testimony at this trial. The state contends that the defendant made false, contradictory, or conflicting statements. If you find that the defendant made such statements, they may be considered by you as a circumstance tending to reflect the mental process of a person possessed of a guilty conscience, seeking to divert suspicion or to exculpate the person. And you should consider that evidence along with all the other believable evidence in this case. However, if you find that the defendant made such statements, they do not create a presumption of guilt, and such evidence standing alone is not sufficient to establish guilt. Such evidence may not be considered as tending to show premeditation and deliberation. Now, members of the jury, before I get to the substantive law that you're to apply in your deliberations, I want to take a moment to go over the jury verdict form. This verdict form will be provided to you in this envelope. There's a notepad and a copy of the jury instructions that I'm reading to you right now, as well as an ink pen. This verdict form, I'll just take a minute to go over it with you. Roughly the top 25% of the form contains what we call the caption of the case. It lists the jurisdiction, that's the state of North Carolina, Wake County Superior Court Division, and it lists the parties, that's the state of North Carolina versus Bradley Graham Cooper. It has a number, a file number. That is of no consequence. That is a number that's assigned to this case by the clerk that helps track it through the system. And below that it indicates that this is a verdict form. In the body of the document, this verdict form reads, and it contains the following language. We, the jury, by unanimous verdict, find the defendant, Bradley Graham Cooper, to be, and there are three options. It is your duty and role as a jury to deliberate upon the evidence, determine what the facts are, apply the law that I'm giving to you now to those facts that you find from the evidence, and reach a unanimous verdict as to one of these three options. The first one is guilty of first-degree murder, or guilty of second-degree murder, or not guilty. At the bottom of the file, or excuse me, at the bottom of the form, there is a place for the foreperson to put the date, sign the form, and print their name. And I'll give you further instructions about that here in just a minute. But that form will be in that envelope that you'll receive shortly after you go to the jury room to begin your deliberations. The defendant has been charged with first-degree murder. Under the law and the evidence in this case, it is your duty to return one of the following verdicts. 1, guilty of first-degree murder, or 2, guilty of second-degree murder, or 3, not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. For you to find the defendant guilty of first-degree murder, the state must prove 5 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim. Malice means not only hatred, ill will, or spite, as it is ordinarily understood, to be sure, that is malice. But it also means the condition of mind which prompts a person to take the life of another intentionally, or to intentionally inflict serious injury upon another, which proximately results in another's death without just cause, excuse, or justification. Second, the state must prove that the defendant's act was a proximate cause of the victim's death. A proximate cause is a real cause, a cause without which the defendant's death would not have occurred. Third, that the defendant intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proved by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the defendant's act, the manner in which it was made, the conduct of the parties, and other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, that the defendant formed the intent to kill the victim over some period of time, however short, before the defendant acted. And fifth, that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proven by proof of circumstances from which they may be inferred, such as the conduct of the defendant before, during, and after the killing, or ill will between the parties. Second-degree murder differs from first-degree murder in that neither specific intent to kill, premeditation, nor deliberation is a necessary element. With respect to the offense of second-degree murder, the phrase intentional killing refers not to the presence of a specific intent to kill, but rather to the fact that the act which resulted in death is intentionally committed and is an act of assault which in itself amounts to a felony or is likely to cause death or serious bodily injury. For you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant unlawfully, intentionally, and with malice wounded the victim, thereby proximately causing her death. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, Bradley Graham Cooper, acting with malice, killed Nancy Lynn Cooper, thereby proximately causing Nancy Lynn Cooper's death, that Bradley Graham Cooper intended to kill Nancy Lynn Cooper, and that Bradley Graham Cooper acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. If you do not so find, or if you have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder. If you do not find Bradley Graham Cooper guilty of first-degree murder, you must determine whether Bradley Graham Cooper is guilty of second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, Bradley Graham Cooper intentionally and with malice wounded Nancy Lynn Cooper, thereby approximately causing Nancy Lynn Cooper's death, it would be your duty to return a verdict of guilty of second-degree murder. If you do not so find, or if you have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. Now, members of the jury, you have heard all the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the district attorney or of the defense attorney, you are to rely solely upon your recollection. Your duty is to remember the evidence whether it has been called to your attention or not. You should consider all of the evidence, the arguments, and the contentions and positions urged by the attorneys, and any other contention that arises from the evidence, and using your common sense, you must determine the truth in this case. The law requires the presiding judge to be impartial. You should not infer from any statement that I have made or question that I may have asked that any of the evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find all the facts and to render a verdict reflecting the truth. You must be unanimous in your decision. All 12 jurors must agree. When you have agreed upon your unanimous verdict, your foreperson may so indicate on the verdict form that I showed you a few minutes ago, and sign it in the appropriate place. To you. When you get this form, it's kind of like the marathon runner or the relay runner, actually, when they get the baton. When you get this, then you can start your deliberations. Do not deliberate until you get this envelope. Your foreperson, when you select a foreperson, you do not have to notify us that you have successfully selected a foreperson. I'll address that at a later time. But when you go to the jury room, just begin by selecting a foreperson. Your foreperson should lead you in your deliberations, and when you have unanimously agreed upon your verdict and you're ready to have it announced, your foreperson should record your verdict, sign and date the verdict form, and notify the bailiff by knocking on the jury room door. You will then be returned to the courtroom and your verdict will be announced.